Well, for more on the Federal High Court annulment or annulment of INEC's electoral guidelines, we're joined by Frank TieTie. He's a lawyer and Arise News analyst. Also joining him is Somna Sambo, Arise News Director of News and Politics Editor. Gentlemen, thank you for being here tonight. I guess let's begin from the legal angle, Frank TieTie. What does this judgment mean? Where does INEC's power begin and the legislative authority take step?
I think this judgment has exposed one area where we have missed the point as a country. The Constitution donated powers to INEC to organize elections, to regulate political parties, to make rules and regulations that guide political parties and to ensure that elections are free, fair and credible. It didn't donate, it didn't delegate that power to the National Assembly. If the National Assembly, we made a mistake by allowing the National Assembly to make laws to regulate elections. How? Why? How possible? When the Constitution has already given INEC the power to organize elections, it was not supposed to be subject to any other authority. If you look at the provisions of the third schedule, particularly section 15 of the third schedule, which define the powers of INEC, the Constitution is clear that the INEC shall organize elections. Particularly paragraph F gives the power to INEC to make regulations. You can't allow people who each and every one of them in the National Assembly who are institutions themselves to now make a law to regulate INEC so that when INEC fails, then it will bear responsibility. The Constitution envisages that. That's why in that particular provision, the Constitution said the National Assembly will make law with regards to any other thing which is not expressly mentioned in the third schedule in section 15. So it was wrong in the first place that nobody reminded the National Assembly that it couldn't have made any kind of regulation to tie the hands of INEC. Now, what I would have expected from that judgment, which was, I believe is fantastic if it was only limited to the Electoral Act, but it failed to consider the supremacy approach to interpretation of law that is this Constitution is supreme. That is, I would have expected the judge to have set aside some of all of those provisions which tied the hands of INEC. You couldn't do such things. These men in the National Assembly cannot organize election. When you allow them to make electoral acts and then make provisions that tie the hands of INEC, you are actually setting INEC up to fail. Now, I'm happy that we have an INEC. I mean, you take away the whole essence of independence of INEC when one arm of the Constitution, one arm of government is able to override the Constitution and take away the powers and functions of INEC and then rewrote INEC by way of a legitimate law. We should have set aside all of those provisions. And I'm happy this has happened because I believe if INEC truly wants to assert its independence and this is taken to the Supreme Court, I believe about 90% of the Electoral Act will be declared invalid and not nullified by the Supreme Court.
Let me bring in our own Somna Sambo here. Somna, the Federal High Court in its judgment, talking about Justice M.G. Umar, says INEC's time frame imposed, underlying that word, imposed on political parties, that imposition is inconsistent with the provisions of the Electoral Act 2026, referred to Section 31 and all the other sections. But now we've just heard authoritatively from INEC that it will appeal this judgment. How does this serve, number one, public good? How does it serve this democracy if INEC goes ahead to appeal this? Should INEC appeal in the first place?
Right, thank you so much, Ngozi. What's happening actually reminds me of the challenges the nation went through in 2007. There was that classical case, Amechi versus INEC, and then there was also that Action Congress versus INEC, which went way up to the Supreme Court. And the Supreme Court had very harsh words for INEC, very, very harsh words. First of all, the Supreme Court was asking, including in other cases that we've heard, why INEC will continue to side with a particular political party and a candidate when it's supposed to be an arbiter in a case. And then also on the issues of imposition of candidates, it was very clear. The Supreme Court said that what the other courts had ruled in Amechi versus INEC, that INEC lacks powers to impose candidates and all of that. In this instance now, you'll be asking, in whose interest will INEC be going to court to go and serve at this point in time? Because, I mean, this whatever has happened now actually favors the political parties. INEC is the regulator of political parties, and the political parties serve public good.
Right.
So whose interest is INEC serving if they are going to do this? Well, we are fully waiting to actually hear what exactly that they want to do. But the constitutional provisions are very clear, and the provisions of the Electoral Act are very clear.
Right.
If you have 120 days before an election by which political parties must submit their candidates, their credentials, and all of that, and the election is January 16th, why will you now bring the deadline from January 16th instead of November, September, and then you now bring it down to May? First of all, the submission of register, and also the holding of campaigns, that's primaries and all of that. Now, if you take a look at it, you will discover that between May, June, July, August, September, you still have 4 months. So why is INEC in a rush? Well, I will say that maybe the reason why INEC was in a rush is because of the failure of the National Assembly to pass the Electoral Act much more on time.
So
that Electoral Act was supposed,
yes,
the National Assembly takes part of the blame, because that Electoral Act was supposed to have been out by December, so that INEC could be able to plan its logistics very well.
Yes.
Printing of ballot papers and all of that. But unfortunately, that didn't come out on time. And that's why you see that even the presidency itself actually failed Nigerians, because some of the provisions being contentious now are because the presidency did not, pay due diligence before signing the Electoral Act. The president was too hasty to sign the Electoral Act without having his team to sit down and actually go through it. Ask yourself, why did the late President Muhammadu Buhari, refuse to sign the Electoral Act for about 3 times, sending it back over? Because he had a legal team that were backing him, giving him ideas, saying this and that. And I think the Attorney General of the Federation and Minister of Justice has failed the nation and failed Mr. President by not giving him proper advice. Because if we have 120 days, which the Electoral Act clearly states, you now wonder why INEC is rushing. And then you also have 90 days window. Why are we rushing? And then the classical interpretation of what the judges have said here also is that INEC does not have the powers to stop campaigns 48 hours before election day. So a lot of things will be unraveled by this judgment. And I think instead of INEC appealing this, they should just go back to the archives and see what the Supreme Court justices had said about court judgments, and the INEC is purely an administrative entity. It is not a judicial entity, and neither is it an executive entity. So you are supposed to be in public service, and when there are judgments that come out in public good, you follow it. Now, this has opened a Pandora box. A whole lot of politicians will now have to go to other political parties if they want, because you are no longer tied to stay in one political party. And that's why the opposition members, you would have heard a lot of them say that the APC was in a rush to bring this Electoral Act to fruition, because the majority of the provisions actually favor the APC. And with the rush by Mr. President to assent to it, it looks like everything favored the APC. But now that we have this open, politicians can defect to other political parties because they still have till September before the digital register can be submitted to INEC, and then before the processes can start. But in this instance, there's one thing that's left there.
Well, I will put you on hold so that you can tell us that's one thing that's left. Somna Sambo and Frank TieTie, let's put you on hold. We'll take a short break and return in a moment. Stay with us.
Well, welcome back to Newsnight. We still have in the studio with us Frank TieTie, a lawyer and a Rise News analyst, as well as Somna Sambo, our Director of News and Politics Editor. Thank you, gentlemen, for staying with us. Frank TieTie, let me come to you. The legal implication of this decision, what does it mean? Because we have the APC that has already started its primaries, and at the end, the governorships were held today with the presidential to hold over the weekend, and other parties that are gearing up. So one wonders if this decision has voided everything about the Electoral Act, and is INEC here not the victim?
No, INEC is not a victim. I'm saying an INEC that is, for once, asserting its independence without expressly saying so. I have maintained, and I will emphasize, that the National Assembly didn't have any basis to make any law guiding INEC on how to organize election. The constitutionality of organizing election, the constitutional function of organizing election in Nigeria is wholly, fully, 100% that of INEC, especially with regards to the list of items that were mentioned in the third schedule, particularly section 15. So if the National Assembly ever made a law called Electoral Act of 2026 attempting to regulate INEC, it was already a failure, and that's the reason why we'll have more confusion. INEC must therefore now assert that it has a constitutional duty. It's not a victim, rather it has a responsibility to the people of Nigeria to assert its independence by organizing the elections irrespective of faulty legislation like the Electoral Act of 2026, which did not have any reason to tie and restrict the hands of INEC. If INEC believes that it is in the best interest of Nigeria and to the success of our elections for certain the times to be abridged, for certain regulations and rules to be made to guide our elections, INEC has that power, and neither the president nor the National Assembly, not even the courts, can restrict INEC in the sense, its understanding, its expertise in organizing elections in this country. INEC takes that responsibility. You can't expect those men with all sorts of different interests other than the betterment of this country to now make a law to that guide INEC. That law cannot be in the interest of Nigerians. It is INEC that has independent-minded people of integrity who man it, who have been appointed in the best interest of this country, in the exercise of the sovereignty of this country, that must now organize elections for us, make rules for the proper conduct of this election. Right. Now, having said so, when you ask me about the implications, I will dare and challenge INEC that if indeed it made those regulations in the best interest of Nigeria and the success of the elections, it must therefore appeal and assert its constitutional duty and function, and not those guidelines or provisions given to tie its hands by the National Assembly under the guise of the Electoral Act of 2026.
Okay, very quickly, Sumner. I mean, you were making a point earlier that this gives some kind of leeway to politicians who lost in their, respective party primaries to defect to another party. Let's talk about the implications, really. Number one, of INEC appealing this judgment, and you are going to talk about that one thing that was left. I hope you still remember, that line of
that's one thing I was talking about, is politicians who have already taken part in party primaries and now defect to another political party within this window now. Yes. What will happen to them? Because those who who refuse to take part in the party primaries could have a legal leeway and say, okay, I didn't take part in this party primary, so I'm defecting to another political party, and of course they can join as members and then contest. But now, if someone who undertook to participate in the APC primaries now loses out, goes under this new arrangement. To another party and registers and wants to contest, wouldn't that be a legal issue? I'm thinking that there's going to be a legal issue there, because you shouldn't be able to contest two party primaries in one election very clearly on that. And then the other issues, before Frank TieTie comes in, I can see you wanting to come in eagerly. The other issues here is that INEC serves public good. And the public good here will be for INEC to just review the guidelines for the election, the timetable, and accommodate everyone. Because if the Electoral Act clearly says 120 days before election, why did you decide to just go and abridge it? That is what the Honorable Justice of the Court was saying. The judge was very, very clear, saying that INEC, you are going beyond your powers. When it comes to the publication of the credentials, of document and all of that, 90 days, I mean, it's there. Why are you tightening the hands of political parties? Why are you setting the date? You set May 10 and then you set May 30th. And meanwhile, there's still enough time. So even if INEC complains that it's because of logistics, the onus now is on the National Assembly and the executive to provide all the funds and everything that's necessary for INEC to do that. Because if we are not careful, INEC is not provided all that's needed, or INEC decides to appeal and it goes to Supreme Court, the tendency is that we may not be able to meet up with the timetable. And then INEC will not be able to discharge all its functions on time, and then the litigations that will be arising will not be concluded before swearing in.
Right.
So everybody has to work. So in whose favor is INEC going to the court to appeal this
And
case?
the implications on May 29.
Because the other opposition parties will
Right.
clearly state that they are doing that to favor the APC. Even when the APC has not asked for that.
You clearly don't agree with some.
I don't agree at all.
Okay, well, political issues and legal issues are different.
No. You see, let me tell you something.
Yes.
I mean, you can't put something on nothing. We have a very faulty law. I mean, a National Assembly making a law with regards to something
You can't take the powers of the National Assembly.
Can you make laws? Are you not going to take away the
Act.
powers of INEC donated to it by the Constitution?
Yeah.
What are you talking about? The electoral
So
act?
do we do away with the electoral act?
Electoral act is
Exactly, that's
faulty. Yeah,
my
absolutely.
point.
With regards to those provisions where it went overboard, where it went otherwise, yes, the court ought to have declared it. Yes, the court gave a good.
I agree with him on
yes.
this. For example, the movement,
hold
the
on,
freedom
sorry.
of movement
Yes.
of people. There is
Association.
nowhere
Look,
the National Assembly could have.
No, the
restricted
National
people
Assembly
from one party
cannot
to the
tell
other.
INEC how to go organize elections. I mean, for goodness sake, how? Why?
So
On
what you're
basis?
saying, Frank TieTie, if I can
So,
hear you,
yes.
if I understand you clearly, there is no need for this Electoral Act 2026.
INEC should say it boldly. We all failed. We all failed as a people and a country. INEC is inclusive by failing to tell the National Assembly that with regards to making regulations to how elections are organized in this country, don't go there, don't make any law. We'll make our own rules and regulations. The Constitution directs us under the express provisions of the 3rd schedule, section 15, paragraph F.
So, but
Nobody told the National Assembly.
Frank,
You can't expect the National Assembly to make laws that will favor others. I mean,
Right.
they'll favor themselves. Why not? That's why INEC ought to be independent.
Before we
Some
go,
not before
again, I want to ask
yes.
if that happens, there'll be a problem because the National Assembly has to continuously serve as a guide.
No, if the court
INEC not to
that will
overreach
set
the power
aside.
because yes, INEC has been given omnibus provisions. I mean, they are the only ones to organize elections, and then of course we eventually have CX. They are the only one who know how to organize elections.
Absolutely.
But no
Absolutely.
power is absolute. That power has to be
Right.
regulated within the provisions of the National Assembly. That's why their budgeting has to be regulated. That's why they're on the first line charge. That's why their commissioners and resident electoral commissioners, both national and rec, have to be screened. Because we shouldn't make INEC to be a country of its own.
No, that's why it's independent. That's why it's independent.
The independence is subject to the Constitution.
I know there are checks and balances in government, no doubt.
I wish
But
we had all
when it comes to
night.
election, INEC is not subject to any authority.
Okay,
And that's what I'm saying. That
INEC accepts its independence.
like for example, the movement of people. Yes, you can't regulate the movement.
It's guaranteed
of
by
people.
the
You
law.
cannot regulate the conduct of elections by law. It's only INEC according to the
We have to
Constitution.
leave it there. Thank you very much, Frank TieTie, is a lawyer and Arise analyst, legal perspective to this development, and of course, Somna Sambo, Arise politics.